Good evening, everyone. We want to welcome you to this latest installment of our Know Your Rights workshop series. My name is Jannelle White. I am the director of the Temp Worker Union Alliance Project TWUAP, which is housed in Warehouse Workers for Justice. We are doing this in partnership with WWJ as well as our partners from the Raise the Floor Alliance legal team. So we're going to start out by going around allowing our panelists to introduce themselves, and then we're going to go ahead and get into the presentation. But before we do that, I want to invite you guys to like, comment, and share this live event. We want to get it in front of as many people as possible. Also, if you do have questions or concerns or issues that you've encountered in your workplace, feel free to leave those in the comment section on Facebook Live, and we'll get those over to Attorney Ada or try to get answers to you and referrals if need be. Thank you to those of you who are tuning in and joining us. And without further ado, we're going to go ahead and let everyone else introduce themselves. Bobby?
Oh, hey, everybody. I'm Bobby Frierson, workplace justice organizer with the Warehouse Workers for Justice. Let me tell you a little bit more about the Warehouse Workers for Justice. Warehouse Workers for Justice is a worker center fighting for the good living wage jobs in Illinois' warehouse and transportation industry. Warehouse Workers for Justice builds political and economical power for working families and community-led infrastructure for progressive organizing in a pivotal area in both Illinois' statewide and national economic injustice fights in warehousing and logistics. Ada?
Thanks, Bobby. Thanks, Jannelle. So my name is Ada Sandoval. I'm a staff attorney at Raise the Floor Alliance. And Raise the Floor Alliance is a coalition of worker centers like WWJ that is here in the Chicago area and in Chicago. And we work to protect workers' rights and to promote more change and policy change for workers. Thanks for having me.
Thank you for joining us, Ada. We appreciate you as always for making yourself available for these events. So once again, this is a Know Your Rights workshop hosted by the Temp Worker Union Alliance Project TWUAP and Warehouse Workers for Justice with our guest, Attorney Ada Sandoval of the Raise the Floor Alliance legal team. So I want to tell you a little bit about TWUAP. So the Temp Worker Union Alliance Project exists to bridge the gap between temp workers and unions. A lot of temp workers are in what we call precarious employment. They're often stuck or labeled permatemps because they don't have necessarily the same pay rate or benefits afforded to direct hires or permanent employees. And they're doing the same work for less pay and less benefits. And we want to make sure that they arm themselves with knowledge and have access to the resources to help improve their circumstance, and hopefully with wall-to-wall union density, because we believe all workers, and yes, including temp workers, have the right to organize. If you would like more information about the Temp Worker Union Alliance Project TWUAP, WWJ, or Raise the Floor Alliance, we invite you to visit our respective websites, as well as our social media pages to get in contact with us, and we'll be happy to engage you from there. Without further ado, I'm going to go ahead and turn it back over to Ada, who's going to go through a presentation. Again, if you have questions or comments, feel free to leave them in the comment section on Facebook, and we'll try and get them to her live. If you're catching this on the replay, you can still leave comments, and we'll try and have an organizer address those even after the fact.
All right, so I was having some technical issues before. Hopefully we're all good, but let's try this out. All right, are you just seeing my screen? Is that what's going on right now? Like a blue screen? Oh, you're muted, Jannelle.
Yeah, that we're just seeing the, there we go. Now we can see the presentation.
All right, perfect. And just the presentation, not my notes, right?
Exactly.
All right, so like I said, my name is Ada Sandoval. I'm a staff attorney at Raise the Floor Alliance in the legal department. And what we'll be going over today is workplace rights and COVID. So just get a little bit more information so that workers know their rights in these situations. And just as an explanation, this is general information. It's not specific or intended to be legal advice. If you do have questions, please let us know. I'll try and answer them as best as I can. In some situations, it might be better to have like a one-on-one with an attorney, but it's still, we welcome all these questions, make it more of a, of a conversation and not just a lecture, but I'm good to lecture for the next couple minutes, you know? And yeah, if you have any other, if you're catching this on the replay, like Jannelle said, go ahead and still ask your questions, and they will get to either Mark or I at Raise the Floor, so you'll still be able to get some answers. So the first topic we'll be covering is the right to organize. And workers have the right to organize under Section 7 of the National Labor Relations Act. And what that means is that when employees engage in concerted activity, like they work together for the purposes of mutual aid and protection to better their situations at work, the employer can't do anything to disrupt that work from the workers. If they do, it'd be violating their rights. So what this includes is the ability for workers, two or more, to take an action at work, like presenting a petition to their employer, or one worker calling on other workers to act. So the call to action. And in order for concerted activity to be protected under the law, it must involve workers discussing work matters. So it's not just like a blanket protection for anything. The activity, the concerted activity, workers working together, does have to be involving work matters. And these protections apply to most employees of private employers, with some exceptions. So supervisors, management, domestic workers, and independent contractors aren't included in the list of workers that the Section 7 protects. But it is good to note, like even if you are like a supervisor or a management, if you think it's kind of just like an empty title where you're not really doing like supervising or management, they just call you that. You might still have some of those protections. And in the case of workers who do exercise their right to organize and the employer does have some sort of like retaliation or tries to do something to stop the organizing in the workplace, the workers' remedies are to file charges with the National Labor Relations Board. In their specific regional director. And there is a time limit. So that's something to keep in mind if you are involved in concerted activity and then something happens at work, not just like getting fired, but maybe they change your hours, they change your duties, your responsibilities at work, make your job more difficult in some way. That can be a charge that you file with the National Labor Relations Board. And again, just keep in mind that there is a time limit of 6 months. So whenever the employer actually does something to change your situation at work, that's when you would start counting those 6 months. And the charge can be filed against either party that interferes with the workers' Section 7 rights, whether that's a staffing agency, a client company, or both. So you would have a charge against both parties if they're both trying to stop you from organizing the workplace. So some examples of protected concerted activity include, but aren't limited to just this, but discussions of working conditions, circulating petitions, discussing joining a union or striking. And this is, so the Section 7 protections are for all workers. It's not just if you're involved in a union. This is the way that workers will sometimes bring a union to the workplace. But it's not, you don't necessarily need a union to have these protections. It's just if you're working and you bring other workers with you to discuss work matters. So a note on strikes though, and work stoppages. So strikes or work stoppages. Employers are able to legally permanently replace striking workers when the demands that they're making to the employer are just limited to economic demands. So usually that's if workers are organizing just for trying to get a raise, that would be an economic demand. So in those situations, the employers could permanently replace the striking workers. But in that case, what you can do is just make sure that when you're trying to organize the workplace, that you address all of the concerns that you have at the workplace, not just trying to get a raise, but if they have like a bad firing policy or there's other working conditions that you can bring up, then it isn't just regarding trying to get a raise or just an economic demand. And that's how you can stop the employers from permanently replacing you. So before we move on to OSHA, I did want to check if there's any questions regarding the rights to organize. If the questions come up later, that's still fine. But I wanted to check in while we're still on the slides.
Thank you for taking that pause. I don't see any questions from our viewers yet, Ada, but I do think it was a good time to pause and just encourage folks again to like, comment, and share. And please don't be afraid to answer questions. You know, we're utilizing this platform to give you access to resources and information that you might not otherwise have access to. So take full advantage of it. Again, even if you're catching the replay, go ahead and leave any questions or comments and one of us will get back to you. And if you're watching live, we encourage you to leave that question so that we can get it to Attorney Ada and get you an answer live.
So the next topic is the Occupational Safety and Health Act, also known as OSHA. So most workers are kind of familiar with that OSHA exists and like certain things at work need to be done because OSHA requires it, but it's also there to protect workers in case of any like safety and health concerns at the workplace. So what OSHA is a federal law that's enforced by the Occupational Safety and Health Administration, and the agency is responsible for ensuring safe conditions in all workplaces. And workers can report any violations or any concerns that they have at the workplace to OSHA. And there is an anti-retaliation provision under Section 11C of the Occupational Safety and Health Act that protects workers from retaliation due to raising concerns about health and safety. This one, as I mentioned before, there is a time limit to some of these claims. And for OSHA, the time limit is that you generally only have 30 days to file a claim. So this one is a little bit quicker. And if anything at work, if you reported something to OSHA and then something has happened at work, like they fired you, or like I mentioned before, if they like cut your hours, they change your work duties, work responsibilities, making things harder for you. If you think that's in retaliation, go ahead and file before it's before that 30 days are up.
Now, Ada, if I may interject here, do workers need an attorney to file that complaint or perceived violation of their rights?
No, and thanks for asking. So you can talk to an attorney, but with the 30-day time limit, it's also easier just to go ahead and like do it on your own. You can look online. They have a way to like, you can either call in and make your complaint, or you can look online and they've made it so that you can do it online as well.
Great, thank you for answering that question. So you guys heard it here. I think a lot of times workers feel like they can't really do anything about unfair treatment in the workplace. But this is just one of a few that we're aware of. Like, not to get ahead of myself or out of turn, but I know that, and correct me if I'm wrong, workers can also file a ULP, an unfair labor practice claim, without an attorney. So there are resources out there available in agencies that exist to help protect workers' rights. So again, if you have questions, if you have concerns, if you're unsure, if you need referrals and need to be pointed in the right direction for your particular situation, we encourage you to reach out to our organization so that we can get you the help and support that you need.
Mm-hmm. And a lot of these agencies have also like tried to make it easy to file things online. So that's something that we can also try and direct you to. If you contact us, we can send you to like the right place online to try and file it, or provide like the correct phone numbers and stuff. But yeah, you do not need an attorney to file a complaint with OSHA.
Although attorneys are great. We do appreciate our friends that serve in that capacity. And if it escalates and there is a need, we do have that referral program as well, through partnerships with agencies and organizations such as the Raise the Floor Alliance legal team. Shameless plug there. I'm gonna plug you guys every single chance I get, because we really are grateful for this partnership and appreciate you guys availing yourselves to workers and defending workers' rights.
Yes, and that's what we want to know. We want workers to know their rights. So you don't always have to go ahead and like file anything, but it's good to know that you have those the opportunity, and that there's somebody that you can ask these questions to, because none of these processes are easy. Like, they're just always there's some complication there, but that you are able to do it without an attorney, although an attorney would also be helpful. All right, and then moving on to, so talking about issues with COVID and workers being retaliated, I like to highlight the Chicago COVID Anti-Retaliation Ordinance, because here in Chicago, there is an actual ordinance put in place to protect workers' rights when employers are trying to retaliate because the worker is obeying like a quarantine order. So what the Anti-Retaliation Ordinance does is it prohibits employers from retaliating against employees for obeying an order issued by the mayor, governor, Chicago Department of Public Health, or healthcare provider having to do with COVID-19, or even for taking care of somebody subject to such an order. And so that includes orders that are like stay at home, because they want you to minimize the transmission of COVID, remaining at home while experiencing COVID-19 symptoms or while you're sick, and obeying a quarantine order that was issued to the employee either by like a doctor, or again, like if there's an order by the mayor, governor, the Chicago Department of Public Health, or by the Commissioner of Health regarding the duties of hospitals or other congregate facilities. And so, and I understand that there are some issues that have been going on with COVID. Unfortunately, if it's outside of Chicago, there aren't really laws in place outside of Chicago currently. But if you're in Chicago, even if like the staffing agencies outside of Chicago, but they send you to a client company in Chicago, then you would be protected under the ordinance. And if you are aware of any violations, if they've violated your rights, you can file a complaint with the Chicago Office of Labor Standards. And there is a phone number here if you want to jot it down, or just come back and replay the video later on. And there are also civil actions, so like lawsuits in court, that are available. So it doesn't just have to go through the agency, but that would be the first step. And you could go through that on your own. You wouldn't need an attorney. And then another,
Can I step in real quick, Ada?
Yeah.
I'm sorry, because I wanted to ask you a question. If it was about the Chicago COVID Anti-Retaliation Act, is there anything outside of the Chicago land that protects workers against or like some type of ordinance like this in place?
So not currently. There isn't anything for like the state of Illinois. And I haven't heard. Oh, go ahead.
Okay, so are agencies such as like, you know, organizing around these issues and using agencies such as OSHA and the labor board, would that help workers in those situations?
It could. I think in those situations, what ends up happening is that they want to, like, these agencies want to know that it's been that there's been like a big outbreak, that it's affected a lot of people. So that's where it gets a little bit more difficult, because if it's just like a couple of employees that are getting sick, but the company is still like trying to fire them or like retaliates because they had to stay at home, that might be a little bit more difficult for like OSHA to get involved, because it's not the numbers. But there are situations where if a worker has been like sick long enough with COVID, it may qualify as disability, and there you might have a discrimination issue.
Okay, thank you.
Mm-hmm. All right, so moving on to earned sick leave. In Chicago and in some Cook County towns, there is an ordinance that gives employees the right to earn sick pay. And that sick pay can be applied to if you are out because of COVID. And in order to earn sick paid leave, a worker accrues an hour of paid sick leave for every 40 hours they work. So that's, if you're like a full-time worker, every week you're accruing about an hour of paid sick leave. And the ordinance does require, like, it does allow employers to require a minimum of 6 months before you can take your paid sick leave. But that would be, some employers might have a different policy. So it's just, they have to follow whatever policy they have in place. They just can't require it to be more than 6 months, because that's what the law is. And employees can carry up to 20 hours of unused paid sick leave over to the next year. So if you've earned however many hours in 1 year and you didn't use it all, it can roll over to the next year. Paid sick leave can also be used for taking care of a close family member who is ill, or for court dates if they're related to domestic violence. And the employer is not permitted to require a doctor's note if you are sick for 3 days or less. So an employer can ask for a doctor's note or require a doctor's note if you've been out 4 days or more, but 3 days or less, you don't have to provide a doctor's note in order to get back to work. And regarding COVID-19 vaccination, workers can take paid sick leave to go get vaccinated. But if the employer is requiring the worker to get vaccinated, they can't tell you to like get vaccinated outside of work hours, and you have to be compensated up to 4 hours per dose if your appointment is during your shift, but that would be the paid sick leave that you'd be using up. Sorry, I might have created some confusion there. So if your employer does not require you to be vaccinated, that's when you have to apply the paid sick leave for the shift, the time that you went to go get vaccinated. But if it does require you to get vaccinated, then you still need to get paid for the hours, and you don't have to use the paid sick leave, again, if the employer requires you to be vaccinated, which some employers have been requiring their workers to be vaccinated. And this only applies, like I mentioned, in Chicago and in some Cook County towns. what happens is that a lot of these Cook County towns opt out of the ordinance. So then it doesn't apply to a majority of Cook County towns. And I do have a list of some of these towns, but it's always best to check with your village clerk to find out if it has opted out, because they might change from year to year. And if you have experienced any violations regarding sick leave or retaliating because you've taken off for COVID, then you can report these violations of the Chicago ordinances to the Chicago Office of Labor Standards. And again, the number is here, but if another way you can get in touch with them is you call 311 and ask them to put you in touch with the Chicago Office of Labor Standards. Violations of the Cook County ordinances, then you would call the Cook County Commission on Human Rights. And other options are to talk to a worker center about how to address these violations through organizing. If it's happening to you, it's likely happening to other workers. And so there's power in numbers and getting the workers together in a place of work. And there's also the option of filing a lawsuit in state court or in federal court if there are other violations regarding federal law. All right, and just checking in if there's any questions.
I literally just checked and no, still no questions. Folks are shy today, but hopefully we'll get some questions in the replay. And if we have any referrals, we'll be happy to get those over to you.
Sounds good. People might be out enjoying the weather, right? Another topic that we're covering today is workers' compensation. And so the general provisions of workers' compensations on the rates of...
I'm sorry,
Yeah,
I was muted. I do have one question that come up with workers all the time, and it's about requiring a doctor note after 3 days. Is it if you call off the third day and you show up on the fourth day, you have to have a note, or if you call off on the fourth day, you have to have a note when you come back on the fifth? How does that work?
Yeah, so my understanding is that 3 days are the max for not having to provide, for not having to provide the doctor's note. So at the 3 day mark, you're good, but it could be that the employers are misreading that. And they might need to be reported. But if you're out 3 days, you should still be good not to have to provide the doctor's notes.
Thank you.
And then, unfortunately, what the issue is as well that the employers try and say, like with COVID, they're trying to just make sure that they know why somebody was out because they're trying to protect the rest of the workers. But that's still there would still be a claim there, and the worker can report that violation of the ordinance. And moving on to workers' compensation. So the rights that workers' compensation provides is for workers with injuries that are suffered on the job. So injuries such as you keep repeating the use of a body part at work, and that just like causes some damage to your body part. Any pre-existing condition that's made worse by the work that you're doing, and injuries caused by equipment at work. And so procedures to follow are you have to notify the employer of the injury as soon as possible, but no later than 45 days after the accident. And this can be, you can tell them vocally, or you can do it in writing, like sending an email or a letter. But either of these would be a way of providing notice of the injury. You also should seek medical care immediately. And you can also speak to an attorney that specializes in workers' compensation, or TWUAP or WWJ can provide you with contact details for an attorney that specializes in workers' comp. So workers' compensation and COVID-19. So there has been protections regarding workers' compensation and COVID-19 because what people were thinking is that if you're getting sick, if you're going to work and then you like end up getting sick, it's most likely that what happened is you got sick at work. So that brought about the rebuttable presumption. And what that means is that when certain types of workers catch COVID, the law just assumes that the worker caught COVID-19 in the workplace. But then the employer has the opportunity to defend themselves and try and show that the worker got it from some other way, or just show like if that worker is the only one that got sick at the workplace, it makes it kind of a harder case for the worker. Unfortunately, the rebuttable presumption wasn't extended past June 30th, 2021. So this rebuttable presumption right now only applies to cases where the diagnosis was made between March 9th, 2020 on and through June 30th, 2021. So if workers were diagnosed with COVID-19 during that time and didn't make like a workers' compensation claim, they may still be able to. However, there might still be that time limit issue where if they didn't let the employer know about it within the 45 days, that might cause another obstacle. But that's still, they might have a claim under workers' comp for their COVID diagnosis. And the workers that are specifically covered under the law regarding the rebuttable presumption are those include healthcare workers, first responders, essential workers. This includes like construction workers, manufacturing workers, grocery store workers, just workers that are like required to interact with the general public or work with at least 15 other employees. And the best way to determine if you are an essential worker for the purposes of like this law, like if you fall under that definition, is to call a workers' compensation attorney, or you can call the Illinois Workers' Compensation Commission, and they might be able to assist you as well. So then, like I mentioned, the employer has to overcome the presumption by presenting evidence, defending themselves, saying that COVID was contracted outside of the workplace.
I have another question. It's about well, injury. It's about a workplace injury. Say a worker injured themselves at work. And the company told them in order for them to report the injury that they had to leave in the ambulance and take a drug test. Is that how that works?
So that's that gets difficult. So workers' compensation, as far as I'm aware, does not require that the employees get tested or go in the ambulance. What happens is that then the employer has a defense that the employee didn't follow their procedure that's in place, which requires like certain steps. So I don't believe that would like make it that the employee doesn't have a workers' compensation case. That would just be like an obstacle that an attorney would have to work with in that case. Because that just sounds like it's a policy in place by the employer, not workers' compensation. Like workers' comp, it from my understanding, doesn't like put those steps right, doesn't outline those steps so specifically.
So if a worker is put in a situation, does the worker have the right to refuse to get in the ambulance and go and take a drug test to report an injury?
So the I would have to look more into it to make sure that the worker would be protected in that instance, because what might happen is that the employer might be able to fire them for that. Because as you know, in Illinois, the employer can fire them for any reason that isn't illegal. And in this situation, I'm trying to figure out if it would be illegal to require the drug test and that they get into the ambulance. So I would have to do a little bit more research on that, because I think that might be something that the employer would be able to get away with, unfortunately, in firing them because they're not following their safety procedure. And especially when it comes to drug tests, like it's the protections there are a little bit in the gray area, especially with like some drugs that have been legalized and some other issues that come up.
Thank you.
Yeah, so sorry, it's not a straightforward answer, but that is a difficult situation. And if that has happened to a worker, I think that's the type of referral to a workers' compensation attorney that would be required. And then you might end up having a couple of different claims there where you have the workers' comp attorney and then another employment attorney helping you out.
No, that's great. And thank you for those questions, Bobby. Bottom line, when in doubt, it's always your best bet to seek out those referrals so that, a worker center such as Warehouse Workers for Justice and even TWUAP has those referrals as well. We can get you to someone who has the answers to those questions. So, don't count yourself out before you've sought out resources to identify whether or not you can actually proceed or should proceed with taking legal action against an employer.
All right, and that was the last topic that I had. So I don't know if there's any other questions that have come up during them. But yes, thank you, Bobby and Jannelle, for the questions that you've provided during this presentation.
Of course, and thank you so much for joining us again today, Ada. And as always, we appreciate the effort that you put into getting the slides together, you and Mark. And to that end, we will be back next week. So those of you who didn't get a chance to ask your questions today, we'll be doing another of these Know Your Rights workshops on the 23rd at noon during the lunch hour with attorney Mark Berhanu, also of the Raise the Floor Alliance legal team. So, and you can also, as we stated previously, watch the replays. And if you have questions or comments, even after the fact, go ahead and leave it. And we'll get back to you. We'll have an organizer get back to you as soon as possible. Before we go, I did want to take some time to talk about some of the work that we've been doing with vaccine outreach and education. I'm going to turn the floor over to Bobby. We have been partnered with the Cook County Department of Public Health, CCDPH, as well as the Center for Disease Control to try and address some of the vaccine disparities in communities that have been affected with high COVID-19 infection rates and coupled with low vaccination rates. So if you are still on the fence, or if you need a booster shot or need your second dose, or whatever your case may be in your vaccine journey, just like with the legal referrals, we want to make referrals to healthcare providers to make sure that you are safe at work.
Thank you, Jannelle. Hey, everybody, once again, I want to talk about an upcoming event this weekend. It's at the Seasons Community Outreach Services. The address is 2959 West 159th Street, Unit E in Markham, Illinois. And it's on Friday, March 18th, from 10 a.m. to 3:30 p.m. And also, I want to suggest that that everybody check out the CCDPH website, which is ccdph.gov, and check out the calendar for upcoming events near you. They may have an event close to you that you may be able to go out to. Back to you.
Thank you for that, Bobby. And also, correct me if I'm wrong, they're still providing free rides to get vaccines. And there's also a link on the CCDPH, I believe it's under the COVID-19 tab, if I'm not mistaken, where you can schedule to have a vaccine appointment come to you. So an administrator will come, it's all sanctioned, above board to the letter, it's safe. They'll come to you, come to your home, and administer the vaccine directly to you there. So if transportation is an issue, if accessibility is an issue, the Cook County Department of Public Health is working tirelessly to try and address those disparities and provide resources to whomever wants them. So again, if you have questions or need more information about those resources, feel free to either reach out to us directly at Warehouse Workers for Justice or Temp Worker Union Alliance Project TWUAP, or go directly to the CCDPH website under their COVID-19 tab for resources and education and vaccine accessibility. So I think that's all we had for today. I want to take this time to thank you to those of you who tuned in and joined us today for this live Know Your Rights workshop series. We are going to be convening again next week on the 23rd at noon. So we invite you to join us again. And we'll have a special guest with us next time from Temp Worker Justice. Super excited to kind of give you a little prequel. I'm kind of letting the buzz out of the cap here. We're going to be partnering with them to do another series of workshops with targeted subject matters, specifically for recurring issues in the temporary staffing industry that have affected temp workers, as well as warehouse workers in general. So keep an eye out for that. Promo should be coming out soon, and they'll be joining us next week. So thanks again for tuning in, and everyone be safe, be well, enjoy the rest of your evening, and hopefully you'll be able to catch the next installment on the 23rd at noon. Thank you, Ada and Bobby, for joining me here today. Always a pleasure working with you guys. Take care, everyone.